Thank you. Miss Moore, thank you.
Thank you, Chair. We continue with the evidence of Mr Horton. Mr Horton, you were asked to comment in your statement about a different event. This is involving D1527, and you discuss this at page 59 of your witness statement, paragraphs 263 and 264, quite briefly. And this event relates to what happened on the 4th of May 2017. So D1527 had jumped onto the D-wing netting. We have seen footage of this previously in the inquiry. He was then persuaded to come off the netting. He went to sit with two other detainees, and in due course, a Rule 40 was authorised. Can we have a look on the screen at HOM 000251, please? This is the DCF1 form in relation to that. So we can see from page 1, it's search conducted on arrival, etc. All of those signatures are S. Dix, that's Mr. Steve Dix. Yep. And we see that you were notified of the use of force, of the use of Rule 40 by DCM Steve Dix at 20 o'clock, so 8 p.m. And so were the other people, so that's you there, D. Horton, being notified. And at the bottom of page 2, we see the record of the reasons for removal from association there, and it says duty director plus Home Office IMB and healthcare aware, authority for initial 24 hours RFA brackets cases of urgency, person authorising RFA SDIX, and it gives the date and the time. So he authorised the removal from association, as we've seen. You were informed of it. What do you do when you're informed of the use of Rule 40?
It depends on the situation. Normally we just discuss what's happened. We discuss the reporting elements, make sure everyone's all right, look after the welfare of the resident and the members of staff. We just talk through the incident, really.
And do you see this rationale as written here? Or is that written after you?
It's not always shared with us before they go on to Rule 40, no.
But you have a discussion, do you, before you, at the time of you being told about it? So we saw 8 o'clock in this instance. Is that when you would have had the discussion?
Yeah, so that's when I would have been told what had happened in the lead up and what's happened as a result. Yeah.
And do you have to take any action, or are you just informed?
No, we're just informed.
And your statement says at 263 that you expect that D1527's removal from association and constant supervision was due to behaviour. Is that a permissible reason to invoke the powers under Rule 40?
When I wrote my statement, I didn't have access to this.
I see.
I had access to one page of an observation of a Rule 40 document, so I had absolutely no idea about the incident when I wrote my statement.
Yes, and I think you did say in your statement that you couldn't remember it, so you were guessing on the basis of the document.
Obviously seeing the document now, then that behaviour is potentially disruptive, potentially causes a risk to the centre and to the others in it, so it would appear Rule 40 is justified.
Is Rule 40 justified with behaviour that's potentially disruptive, full stop?
It very much depends on the behaviour. It should be a last resort if that behaviour cannot be de-escalated, or if there's a potential risk of ongoing disruption to the regime or to the residents, or if behaviour causes, a safety concern. So yeah, you should always try and de-escalate and try and find an alternative to Rule 40. But if you can't, then yeah.
And that could include if, as a last resort, you can't do anything else about the disruption to the regime and the residents, you say?
Yeah.
Where did you gain that understanding of the parameters of Rule 40?
Just, in general knowledge of sort of conducting the role. We needed to sort of upskill ourselves slightly in it, but I had no formal training when I moved into the role of DD on the sort of use of Rule 40.
And just to check there on the form, Steve Dix, we've heard from him already. We know he was a DCM at this point, wasn't he? And were DCMs entitled to authorise Rule 40 per your understanding?
That was the standard working practice, yeah.
in any circumstances or in some circumstances?
So generally, Rule 40 is invoked on two different ways. It's either a planned incident where, for instance, a resident might be leaving on overseas removals the next day, and there's the potential for disruption, so authority will be sought. So for any planned use of Rule 40, a case is put to the Home Office, and the Home Office will approve that use of Rule 40. Generally, when a DCM or DOM is making that decision, it's based on the fact that they're in the middle of managing an incident. So, the ability is not there to go away and seek planned use of Rule 40.
I wonder if we could have on the screen CJS 000676. This is the DSO that pertains to Rule 40 and 42. I'm just going to ask you to look at the rule rather than the DSO, but it's just a document that contains it. And I want to look at paragraph 28, which I think is on page 10. Sorry, 11. Thank you. So it just sets out Rule 40 there. So it says at the top, the Secretary of State may arrange for the detained person's removal. That's, as you say, that when you have time to go to the Home Office. And then 42, in cases of urgency, which is the wording we saw on the form, the manager of a contracted out detention centre may assume the responsibility of the Secretary of State under paragraph 1, but she'll notify the Secretary of State as soon as possible after making the necessary arrangements. So did you understand that to be this example we looked at to be an example of section 42? And the manager of a contracted out detention centre, did you understand Mr. Dix to be the manager for the purposes of this rule?
For working purposes, it's always, as far as I can recall back in history, it's always been the case that a DCM or a DOM or a team leader had the authority to do that.
And that was what you were told when you took on the role? In a not a training way, but you were told.
Yeah, I mean, it was part of I was a DCM or a team leader before doing the role I did then, and it was I signed people up for an urgent Rule 40 at the time. It was sort of that's just what we did.
Fine. And if we go to page 7, please, this is the first bit of the rule that I just quoted. So under paragraph 9, again, it's Rule 40. Rule 41, where it appears necessary in the interests of security or safety that a detained person should not associate with other detained persons, either generally or for particular purposes, and then it goes on to say the Secretary of State's powers. So when it's necessary for security or safety, that doesn't include, does it, when it's necessary to avoid disruption to the regime?
Significant disruption to regime would have a significant impact on safety in the centre.
Does disruption to the regime always engage the necessity of the interests of security or safety being protected?
Not always, no.
And do you think, or from your memory, when Rule 40 was used, was it always necessary in the interests of security or safety, or was it sometimes just to avoid disruption?
From memory, I would say it was around security.
So sorry, go on.
No, it's okay.
No, please go on.
No, I'm not. Again, it's I suppose, it's a definition maybe, or an interpretation of what you think that wording might mean.
So I know that you weren't the person who authorised the Rule 40, but just because we were looking at it as an example in relation to 1527, Mr. Dix was the one who authorised it, but 1527 had come off the netting and was sitting in a room with 2 other people at the time. Did you consider it still was a disruption to the level of making it necessary to secure the security and safety of the centre?
I wasn't there at the time.
Do you think that would fulfil your understanding of what disruption means for the purposes of this rule?
I can't make an assessment on whether it was because I wasn't there at the time. The DCMs that attended that and managed that incident made a decision based on their assessment. I can't make a comment on what their assessment was or wasn't.
But you'd agree, I think, and as you've suggested, maybe it needs to be more than just disruption.
It's whether yes, it depends. Was there a belief that he could have gone back onto the netting? Was there a belief that there could have been, other issues? I don't know. It's very much done on a risk assessment at the time.
Okay. And Mr Dixon, his evidence to the inquiry on the 9th of March 2022, alluded to a procedure at the time about, 2017, where if someone was on the netting, the procedure was for them to go on Rule 40. He wasn't sure if that was the policy, but he said that due to the level of disruption of him being on the netting, people do generally go on Rule 40, or he said E-Wing or CSU. Do you remember that being the general kind of way of things went?
I don't remember at the time in that specific instant. What I can say now is that it's very much not the case that it's a default move. Someone goes on the netting and then they instantly go onto Rule 40. I've been duty director on call numerous times when people have got onto the netting and not gone to Rule 40. So it's very much situation based.
And you don't remember about 2017, whether that was more common for people to go on Rule 40 after going on the netting?
I can't recall whether, it was quite frequent from what I can recall of people going onto the netting. I can't say whether all of them went onto Rule 40, whether some did.
Yep. And finally on this, you authorised a strip search, which you discuss in your statement. Can you just help us with, again, I understand you can't remember the details of the exact assessment you made, but at the time, in what circumstances would you be able to authorise a strip search?
So a full search is, we would authorise that based on if there's again, it's risk-based. So it's very much dependent on what's being reported to you at the time. When someone's seeking your authorisation, or like in relation to this incident, it would appear that there was a significant concern that the person had something about their person that they could have used to cause harm to themselves. So in that instance, yes, I would have authorised a full search to make sure that, where possible, we could reduce the risk of that person using that sort of item to hurt themselves.
And do you know what information you'd have before you on making that decision? So is it a conversation? Do you look at written records?
Again, it depends on the situation. If you're in the centre, you've got access to written records and to the sort of database system, so you can go back and look at history. If it's on the phone and you're on call, you wouldn't necessarily have access to all of that data. It might be that you have to make a decision based on what you've got, the information you've got to hand, and not historical stuff. I generally would expect the DCM to give me a bit of a background on the history of the person.
Help me with the in the centre versus on the phone. Is that because as DD you might be at one of the other centres even though you're the DD who's in charge?
It might be at 2:00 in the morning.
Okay, so it's not always that when you're the DD you're there personally?
No, okay. No. So if you're duty director, you're on site for a period of the day, but then you'd be on call at home. And
there's no other duty director there, you're the duty director and you're on call. Fine. In this circumstance, the full use of force forms that we've been through in some detail with the people who are present, and I appreciate that's not one of you, have different accounts. So some suggest that there was an unknown object and some suggest quite clearly it was a phone battery that had been removed at the time. And so there was nothing on his person because the phone battery was on the floor. And indeed, I understand nothing was found after the full search. Would you have looked at the sort of documents like that, so the use of force accounts of the people who saw him at the time when he was holding the object?
What, at the point of making the decision on the full search? Generally, the reports aren't written at that point. I don't know when the full search took place. You're asked afterwards, and no, so you won't always have those reports. And
so you go with the sometimes verbal account of normally the person who is asking you, so Mr. Dixon.
They'll ring you for authorisation, and they'll give you an account and ask for your authorisation. And if you're not content that there's enough information in there, then you can obviously turn around and say that I don't want to authorise it, or you need to come away and give me some more information that would allow me to justify that.
Thank you. And a question I should have asked earlier when I was asking you about the last event. So when you mentioned PPE being used and the need to get kind of dressed up in PPE, it's just another question about policy and what practice was. So I asked you about the netting and whether it was policy to put people on Rule 40 after that. should have also asked you, was it policy at the time that every time you did a planned use of force, you had to use full PPE?
That was working practice, yeah.
And is that still the case?
Pretty much, yeah.
And is that like a G4S Serco policy? Do you understand it to come
No,
from
I mean,
somewhere else?
my understanding of it is that's a HMPPS standard as set out in their manual, or the control and restraint manual. I know Mr. Collier's mentioned it, and I think it came as a bit of a surprise to a number of us when we read that recommendation.
Yep.
I think the working principle's always been that you use PPE.
Okay.
I think it alludes to the fact, I think it mentions about a risk assessment. But I don't know. I mean, we've tried to work through it. I don't know what sort of risk assessment you could do. So yeah, generally PPE is always worn for a planned use of force.
Thank you. I want to move on now to ask about your relationship with the Gatwick Detainee Welfare Group.
Yeah.
So this is pages 56 and 57 of your statement from paragraph 250 onwards. So you first mentioned the Memorandum of Understanding, so the MOU
Yeah.
at 250. And we heard from Mr. Gasson yesterday, who believed that the MOU had been agreed, but your evidence, and indeed that of Gatwick Detainee Welfare Group, seems to be that it wasn't agreed.
Yeah, that's correct. I don't think I ever. So part of my remit was to look after third parties, or to manage the MOUs or the SLAs that were in place. And I don't recall having a signed MOU.
But you were told to act according to the unsigned, as if it were.
Yeah, I was told to act within the bounds of it.
Do you remember who told you to do that?
It was there was a direction from the Home Office and from senior leaders at Brook that is how I should manage the relationship.
Who from the Home Office?
I believe it would have been Paul.
Mr. Gasson.
Yeah.
And you mentioned at 251, my role was to manage the MOU. Ben Saunders, Neil Davis and the Home Office set the agenda on how they wanted to manage the relationship, and it was my role to follow that through. So the same people you've just mentioned there. You refer in your statement, I'm still on 251, to some correspondence between yourself and Miss Pincus of GDWG,
Yeah.
in which Mr. Wilson and Steve Skitt and Paul Gasson are all copied in. So I won't turn up the Verity report unless you want to look at it, but the short version is Gatwick Detainee Welfare Group were requesting a room in which they could hold focus groups with detainees.
Yep.
I think the idea was to talk about and to improve Gatwick Detainee Welfare Group's work, and you were the one who refused it. And you say in your statement that you recognise that was unhelpful.
I recognise the tone was. I think that specific one, the email I sent back to Anna said, I've sought guidance on this. So it wasn't my decision to refuse it.
That was going to be my next question. So
sorry.
whose decision was it? No problem at all.
I don't know who specifically made that decision. In that case, I suppose, like I've sort of said, I did feel, very much like the middleman. I didn't set the agenda for those, for the relationship with Gatwick Detainee Welfare Group.
And as to who set the agenda, is that the same people I've just mentioned?
Yeah, and I think James Wilson references a conversation he had with Ben, where Ben raised concerns and conversations with Paul and Neil and Steve Skitt.
Did you say Paul and Neil and Steve Skitt?
Paul, Neil, Davis,
Yeah.
and then it turned into Steve Skitt. But I think obviously Steve as the DEP would have taken a steer from Ben.
I see. And you were, I don't want to say middleman, but you were you were communicating with the GDWG, but not with always decisions that you'd made on your own.
Yeah.
And you say at 252 that the Home Office and Ben Saunders were concerned that the GDWG were trying to offer legal advice or create a surgery, and they felt that crossed the boundary.
Yeah, I think sorry.
No, please.
I think the view very much was that Gatwick Detainee Welfare Group were there to provide a social visit service for residents that didn't have anyone to come and see them. The drop-in sort of sessions were there to triage people, so they were there as a sort of introduction for them to pair a suitable volunteer with a suitable resident to have social visits. Therefore, the view was that why would you need more than one visit in that drop-in surgery? And I think it's documented in some of James's bits that there'd been a number of, or G4S at the time and the Home Office raising concerns about the role Gatwick Detainee Welfare Group were taking with residents in terms of supporting them with legal matters and ultimately supporting them in preventing removal.
So in terms of supporting them with legal matters, obviously Gatwick Detainee Welfare Group aren't a legal entity.
No.
There's no suggestion, I don't think, that they were litigating on their behalf or providing legal advice. Is this a reference to a witness statement that was made by a member of GDWG in 2015? Were you aware
Yeah, I
of
think
that?
that's what kept being referenced, yeah.
So this was a detainee who was mentally unwell. The GDWG member of staff provided a witness statement about his presentation, and he was ultimately, I understand, released from detention, and indeed there was a claim that was successful or was settled maybe for unlawful detention.
I don't know the details of that 2015 one.
Fine,
Yeah.
but it was mentioned.
Yeah, it's in there that says it.
People up to 2018, according to Mr. Wilson, were still talking about it and raising it as a...
It was still raised in, I mean, as you can see from James's, they kept raising similar things.
Did you think that was fair?
I think the Home Office and G4S in supporting that had a concern. Is it right that you keep raising the same thing? I don't know. I think there were other things that were raised as well. From memory, I believe there was a concern raised that someone from Gatwick Detainee Welfare Group had contacted us requesting multiple drop-ins because they were helping to manage someone's mental health, and that they needed to see that person to continue supporting them.
Yep.
I think the concern was that they hadn't raised that with G4S or with the Home Office. So I think that raised some concerns that how are we supposed to safeguard that person in the centre when that information hasn't been shared? Our healthcare department wouldn't have known about it. We wouldn't have, so I think that that was one that I recall that I think was brought up as a concern. So I think those things combined, the Home Office had an issue with. Yeah.
And just to be clear, when we refer to drop-ins, it's not in drop-in in the normal sense of the word. So Gatwick Detainee Welfare Group obviously didn't have free access to the centre.
No.
And neither did they have a room in which detainees could come and drop in, similar to the sort of welfare office that you do have at Brook House. It was a pre-arranged and pre-booked room.
Yeah, it was like a pre-booked room in a visits corridor. Yeah.
And they'd have to say who they were meeting in that room. It wasn't drop-in for anyone. But the difference, I think, from a normal visit is instead of being in the public kind of big room of the visits hall, it was a private room.
It wasn't a social visit in the social visits area. It was in a small contained room.
Yes, and detainees could have one of those private visits to ascertain the sort of support they'd need, who might visit them, etc.
Yeah.
And then they would be allocated a visitor to see in the visits hall. And sometimes, as you say, Gatwick Detainee Welfare Group would ask for a second drop-in or second visit.
Yeah.
And we've seen examples of them saying it might be because someone shared something concerning on their first session. They wanted to discuss it again in private, and the busy visits room wasn't the place to do it. They hadn't had a full assessment of their needs. That's reasonable, isn't it?
I don't disagree, but I think where the concern would be was that information shared where there was a first concern, or were Gatwick Detainee Welfare Group keeping that information to themselves and managing that resident without sharing it to anyone else? Because that is really risky, because what's to say that resident doesn't go back to his room and try and harm himself, and we haven't put around the sort of safeguarding that we should do. So I think it was little incidents like that I think were raising the concern profile.
Was that shared with Gatwick Detainee Welfare Group, in your view, adequately? Were they told, the reason we're worried about these repeated visits is because we really want you to tell us when you have a concern about a detainee? Or were they told, we've agreed one visit per person and that's all you're having?
I mean, I can't really recall in really great detail those visits those meetings that I attended. I believe they were raised, and I believe we were saying to James, look, that those were some of the concerns we were having. Mm-hmm. I know James references, the 2015 and references similar things being brought up, but that's where the concern was emanating from, and the concern also was that some of the activities that they wanted to get into were very much in conflict with the Home Office priority to remove people.
What sort of activities?
In terms of offering legal support, sorry, I've hit the microphone again. In terms of offering legal support, so putting them in touch with legal providers, providing evidence for case notes, bits and pieces like that, I think is what the concern was.
Was contrary to the Home Office's
Yeah.
desire to remove people?
I mean, that's my own opinion. I can't
Sure.
speak for the Home Office or what Paul was, but that's definitely the feeling I had.
And you say at 255 you think there were discussions around removing the drop-ins, but you don't think it would have actually occurred.
I would have been shocked if they'd taken away the drop-ins, yeah.
So they were empty threats.
I would have been surprised if they'd taken away. They might not have been, I don't know.
Fine. They weren't, as we understand it, in 2017. But do you know whether these discussions or threats to remove the drop-ins were made not just internally between G4S and the Home Office, but actually GDWG were aware of them? Because Mr Wilson recalls being at a meeting, he doesn't say you were there, with Mr Gasson and Mr Skitt, where he was told they'll be taken away.
Yeah, I wasn't at that meeting. I was on leave. So I don't know what took place. Obviously, what James has provided, he says that's what was said.
Okay. But you recall there were discussions at the time about potentially removing the drop-ins.
I don't think that they would have been taken away.
And you don't know whether GDWG were made aware or how they were made aware that
No.
might happen. Fine. I want to ask about your role on complaints now. So you describe this at page 11, paragraph 185 onwards. And you say you oversaw the complaints clerk at Brook House, and we saw it at the start of your evidence on the organogram. Was that Karen Golder?
Karen, yeah.
And in brief, what did your complaints role entail?
So it ensured that it was there to ensure that the process within the sort of DSO was followed. So it was there to ensure that complaints we received from the Home Office on DCF 9s were investigated and responded to, and then shared, obviously, with relevant people.
And did you decide who would investigate any given complaint, or did Karen?
Not generally. It generally wasn't Karen or I that decided. The general process was that the complaint would go to the relevant functional head. So if it was a complaint about something that was happening residential, it would go to Jules for him to decide who would look at it. If it was a complaint that related to property and reception, it would go to the functional head for that area.
I see. Did you have training on how to manage the complaints system or handling complaints? Did Karen, do you know?
Karen, no, I don't. No, there was no. We weren't trained on it.
Were complaints and the responses to them audited or quality checked by anyone?
Yeah. So I did a 10% audit of complaints, looking at to whether they fell in line with the DSO. Karen would then send the results of those quality checks out to everyone.
The departmental
Yeah,
heads?
to the relevant person or the person that had completed that complaint, for sort of like a lessons learned or like sharing of practice. And then all the complaint responses were shared back with the Home Office, so they were all sent back to their central team.
And we've heard evidence from Mr Darren Thompson. You've been provided with, I think, just the relevant page from his evidence on the topic. But he says, and about him is said, 13 complaints were made over a 3-year period. And he was asked at any stage during those 3 years, did anyone not just look at the individual complaints, but take a step back and say, Mr Thompson, you've had 13 complaints over this period of time? And he said no. Did a certain number of complaints against someone trigger any kind of broader consideration of what's going on?
So there wasn't a system in place for that. There is now, and rightly so, and it's monitored really closely. So we share, we have like a cultural spreadsheet that we share with the Home Office and the SMT, and that will capture a number of different indicators, but it captures resident complaints, staff complaints, grievances, number of uses of force that a potential individual's taken on. We meet every 2 weeks to sort of review that and to look at that. So, there was nothing in place at the time, but post Panorama and in the new contract with Serco, there's a lot more scrutiny on it, so it wouldn't be allowed to happen again.
And in relation to the cultural spreadsheet with those data that you mentioned, when did that come into place?
It started to come into place after Panorama. It was part of the Panorama action plan, and I think it was the DEP that was that had oversight of that. So all the sort of relevant complaints were shared, and we started to look at it. It's been refined quite significantly since Serco taken over.
And you say you meet every 2 weeks.
Now we do, yeah.
Who's at those meetings?
So it is chaired by the DEP director, Sarah, and then the compliance manager or ops manager from the Home Office comes.
So Sarah Newland.
Sarah Newland
Deputy
chairs.
Director. Yeah.
And then it's generally I've forgotten their titles now, the operations manager. It's Natasha Barber, generally from the Home Office locally, that comes along, and another ADs. And Steve Hewitt often comes.
And do you look at what's happened in the previous set period of time, and how do you get an idea of the longer
So there's
scope?
an ongoing spreadsheet.
Yeah.
So that'll just, it just keeps being added to.
Okay.
So it's not a snapshot of a time period. It's a consecutive or like a continuous record.
Okay. Going back to complaints as they were in 2017, just briefly. Obviously, you have a population who move around, might leave the centre. What could you or Miss Gold or any of the people investigating the complaints do if there's a complaint but they can't fully investigate it before the detained person has left?
Sometimes it was difficult. We always tried to make contact if we could. So if they'd moved to another centre, we would try and make contact with them there. If they'd been released and there was no address, then it was difficult to make contact. Or if they'd been removed. So we would, if someone had left and there was no forwarding address, we would still investigate it, and we would still write an outcome to that investigation, and we would still send it back to the Home Office. We just couldn't inform the resident that there'd been an outcome.
Or hear their account, potentially, if they've left.
Or potentially hear their account, yeah. I mean, generally the accounts are fairly descriptive that they write on the DCF9s.
Right.
So you would have to go by that.
I want to ask you about a specific event. So this is your involvement with Mr. Instoneborough and Mr. Fagbow's disciplinary. So the inquiry's seen notes of a 2017 interview with Michelle Brown, and you've been asked about it in your statement. She was asked, can you tell any more about Mr. Instoneborough and Mr. Fagbow, and said, I think during 2016 a detainee made a complaint against them for poor behaviour, bullying and inappropriate behaviour, which was substantiated. DCM James Begg investigated and reported to Jules Williams. It was due to go to disciplinary, but Luke Instoneborough submitted a grievance and the disciplinary was paused. The grievance took 8 months. Stacey Dean was allocated to it, but she fell ill. Kaz Dance Jones heard it in November 2016 and it was partially substantiated. Dan Horton had been given the disciplinary to do, but he forgot to do it. So according to Miss Michelle Brown, you were supposed to investigate, and she says you forgot. And she says in her recent statement to the inquiry that when she asked you about these circumstances, you said that the investigations didn't occur due to absences and failures in managing DCO Fagbow's absence. I understand that you say you talked about, sorry, it's not the first time you've heard about her saying you forgot, is it?
No.
You heard that much closer to the time.
So she mentioned it, I suppose, there. And I can't remember in what setting. I don't know if it was in a meeting or if it was coming out of something. And I remember all I can recall is my initial gut instinct and my reaction. And I said to her, I don't think you're right. I might not use that language. But I remember being quite surprised. I didn't recall having it. At the time when she mentioned it, it felt like she was blaming me for forgetting something that I had no knowledge of. I find it, looking at it now, I can't recall it. I can't recall being issued it to complete. I find it surprising or hard to believe that a grievance or a disciplinary outcome that would have been issued to me by a senior manager or by HR had just been allowed to not take place, because that wasn't a common thing. So surely if I'd been issued a pack and given an instruction to complete a disciplinary, there would have been a catch-up or a check-in, say, how are you getting on with that disciplinary, Dan, or when at the point I said, "Oh, I forgot about that," I would have completed it. So whilst I can't recall it, it doesn't feel right to me, and as far as I can, I deny, her comment. I can't see how it'd be allowed to happen. I have never forgotten to complete a disciplinary in my career, so yeah, I can't see how that would take place.
Is the disciplinary investigation scheme, or was it, different from the complaints investigation scheme that you were ahead of with Karen Golder? So it's not the case that because it's a disciplinary, it would have been for your team to process?
No, I mean, if there was a resident complaint of bad behaviour that had been investigated as part of the complaints and substantiated, that would have then generated, sort of within G4S, its own internal sort of disciplinary procedure.
And who was in charge of the disciplinary process?
I mean, it was coordinated by senior managers and HR. Right. So you would have had, someone would have said, this isn't appropriate, I'll issue terms of reference for an investigation.
Yep.
You would have gone through a disciplinary hearing and more fact-finding, more evidence collation. That would generate an outcome or a report to say what the findings were.
Yep.
That report would then be issued to someone to have an outcome, be that disciplinary, be it no further action, be it whatever the action might be.
It could have been someone at your level to whom it was issued to deal with it, but it could have been somebody else at your level, is that right?
Yeah, I mean, it could have been, for the investigation, it could have been a DCM that was investigating, and then it would have come to a senior manager to do the disciplinary.
I see. That's the only thing I wanted to ask you on that, and now I want to turn to your reaction to Panorama. So I assume you watched it.
I did.
And you've watched some of the evidence, I understand, so far given to this inquiry.
Yeah.
What's shown on the footage and what we've heard so far paint a picture of a negative culture at Brook House at the time. So we see things like swearing and disrespectful language used towards detainees, a lack of understanding of people in crisis, perhaps, as well as the more tangible acts of abuse that we see as well. And we've heard and seen staff who were overworked and felt understaffed. Was this the same as your impression of Brook House on the ground during this time, or did any aspect of what you saw surprise you?
I think it was horrific. The stuff that was shown on Panorama. And I wish that we'd had the processes in place to identify it. Because I remember sitting there and it just being in such stark contrast to the job I knew that the majority of people did. I wasn't aware of that behaviour and I hadn't seen it. Had I heard swearing and, yes, it's, people do swear. Had I heard it directed towards a resident inappropriately? No. But no, I definitely didn't think there was a culture of abuse and, what was seen on Panorama. It was horrible to watch.
You said, I wish that we'd had the processes in place to identify it. What processes do you think might have helped you to identify it?
Well, going back to things like the complaint, the Darren Thompson thing, the cultural stuff that we've got in place now definitely helps us identify people that are more often or not involved in resident complaints or uses of force, those types of indicators. It's not to say it's perfect, but it's the fact that none of us registered that was happening. It was hard to take.
One thing we've heard about specifically is the lack of mental health training for officers. Did you were you aware of that at the time?
Yeah, so part of my remit was training. So we delivered mental health training as part of the ITC. I think it was about a 4-hour session in the morning. It was part of the prison service package around self-harm and suicide prevention. So it's called an introduction to mental health, and that was the sort of established standard that people needed to complete. Again, I've heard mental health training discussed a lot in the inquiry. And again, it's a difficult one to quantify what the right amount is, because we're not training people to be clinical staff. We're not training them to diagnose. What we want our officers to be able to do is identify a concern with a resident and say, I'm not happy with that, and refer them to the professionals for them to have a full and proper assessment with a medical professional. We do more now. Lee Hamford, and I, as part of Post Panorama, introduced mental health first aid training. So that came online in 2018.
What does that consist of?
So it's a day's training. It's affiliated to, and I might get this wrong, so please excuse me, the British Mental Health First Aid Association. I can't quite remember if I've got that right. It's a bit of a tongue twister.
That's fine.
But it's a set program that's a certificated course. We went to a training provider. I can't recall 100%. I think it was AID training. They did a lot of work with us for first aid and then some other bits and pieces. So I think we went to them and they sent us a sort of qualified trainer. So it was a day session. We introduced it to the ITC. So all new officers were getting it, and we introduced a program where existing staff would attend the ITC to also get it. So we were upskilling not only the new staff but the existing staff, and we tried to prioritise the sort of E-wing and CSU staff because that's obviously where it is. But again, that training acts, it's about identifying risk with a person and with yourself. So it helps you identify mental health concerns with your colleagues and yourself, so you can look after yourself, but it also helps increase your understanding of certain mental health conditions, and it gives you a bit more of an insight into the triggers or the signs to look out for.
I know you can't train everyone at once, but is that going to be mandatory?
It is now.
It is mandatory.
As far as I believe, it's mandatory now. It's part of the ITC.
And have you been able to assess the efficacy of that? Do people feel it's helped them to, as you say, identify concerns?
I think, especially from my role now, I believe the staff group are brilliant at raising concerns about vulnerabilities, including mental health. We've done so much work around vulnerabilities. It's still not. We can still do more. We always can, but we get staff raising concerns really early about people they're concerned about for a number of different reasons, be it a withdrawal from regime or sort of a change in behaviour. We monitor it. We've got weekly sort of vulnerability meetings where we manage our sort of real risky people. So I think it has had an impact. Does it still, we look after at Brook House some mentally unwell people. We look after people that are on section. Are staff adequately trained to properly manage someone who's under a section? No, but they would need to be clinically trained in order to do that. They do an amazing job and have some amazing results in the last year or two. There's a number of different residents that have had very good outcomes based on the staff interaction with them, but they're not clinical staff.
So you rely on the clinical staff that you have there as
we
well?
We rely on the clinical team, to give us a steer in how best to try and look after them.
And do you think that your staff are getting an appropriate steer from that team?
I think it's a lot better than what it was. There's a lot more multidisciplinary working that goes on, and a lot more input from healthcare and the clinical side. Yeah.
And you've said you acknowledge Brook House isn't perfect. You can always do more. You're now assistant director. If you had to identify a couple of things that are next on your list for what you want to achieve to continue to improve, what would they be? In
my remit, the things I'm focusing on at the moment is the care plans for ACDTs and making sure that they are more holistic and there's better support in there for the residents to try and manage their risks. We're looking at adults at risk and trying to really improve staff's basic knowledge of it. It's better than what it was. So that's part of a new document and DSO that we're rolling out called Vulnerable Adult Care Plans. So they're, ACDT care maps, AAR, adults at risk, and also just we're just trying to raise the profile of safeguarding really at the moment.
Thank you. I don't have any more questions for you, Mr. Horton. The chair may have a question or two for you.
Thank you, Mr. Horton. Just a couple of very brief ones about how things are in Brook House now. What's the minimum number of DCO staff that you have on the wings at the moment?
I believe it's 3 on the wing and 1 for courtyard. So there's 4 officers to manage the wing and 1 dom. So there's 1 manager per wing.
So what would have been a DCM but is now
So what a DCM was, yeah.
Okay, thank you. Do you have staffing shortages at the moment?
Yes.
And can you tell me a bit about why that is?
It's very difficult to recruit into. It always has been, to find the right people. So that's one thing. We found recently in the last few months it's a very competitive labour market. So lots of people are, where we had a surge of recruitment during COVID, where people were displaced from their sort of professions, those people are now going back to their previous professions. And it's a tough place to work. It's not an everyday job, and I don't think it's something that, with all the training in the world, you can fully prepare people for. So I think some people get into it and realise that it's not for them. It's the officers do a very, very tough job. So you naturally lose more people than most industries. I think Serco have improved conditions for staff, but I think you will always have conflicts with pay. Can you get paid more in other less pressurised roles? And I think that drives some of the recruitment or some of the retention issues.
Thank you very much. I have no other questions for you. Thank you very much. I know you've been with us for a long time today, but I'm very grateful for your evidence. Thank you.
Thank you.
Ms. Moore.
Chair, it's 10 to 3 now. If we return at 5 past for the evidence of Mr. Cheeseman.
Thank you very much.
All rise.
Thank you very much. Thank you.
Chair, the witness this afternoon is Mr. Ian Cheeseman.
Thank you very much.
Oh, thank you.
Can you just repeat after me? I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you. Oh, lovely. Thank you.
Take that out of your way.
Oh, that's very kind. Thank you.
Thank you. Can you give your full name to the inquiry, please?
Yes, it's Ian Cheeseman.
And Mr. Cheeseman, you made a witness statement for the purposes of the inquiry, and the reference is HOM 0332154. I'm going to ask you about some of the topics within that statement, but because I'm going to ask that it's adduced into evidence in full, that stands as your evidence, and I may not ask you about every single line of it, so that you understand that. You previously worked from the Home Office. I understand you retired in 2020, is that right?
That's correct.
Whenabouts in 2020 did you retire?
November the 20th.
And prior to your retirement, you worked in various different Home Office departments, you say for 33 years from 1987, is that right?
Yes.
You worked in a number of different roles as executive officer, higher executive officer, and senior executive officer, and then as a grade 7 civil servant. Were you a grade 7 civil servant when you retired?
Yes, I was.
You latterly, you say, worked, your main roles were in the policy area, is that right?
For the last 25 years of my time in the Home Office, it was mainly policy work, yes.
And you were a policy advisor, and you say that you did not therefore have operational functions or direct roles specific to the Brook House Immigration Removal Centre during the relevant period, is that right?
That's correct.
You again say that you were a policy advisor in the Home Office unit responsible for, among other things, policy concerning those deemed to be vulnerable in a detention context, is that right?
Correct.
A principal responsibility in this context was the framework for developing Home Office policy on making operational decisions on whether to detain an individual or to continue to detain an individual considered to be vulnerable. Is that right?
Yes.
And that was the main role that you had prior to your retirement.
Yes.
You also, you tell us in your statement, were involved on a secondment to the Shaw Review. Is that right?
Yes, it is.
And you were part of his team seconded from the Home Office. Do you know why you in particular were suggested for this role, or did you volunteer?
I was working in asylum policy at the time. I'd worked there for about 6 years, I think, and usually in the civil service you move around from time to time. And I just needed a new challenge. I put my name out there. The Director General's Chief of Staff was aware of this, and she suggested me for this role. I met Stephen Shaw. He seemed okay with me. I was happy to do the work, and so I moved there.
And was your background in policy in relation to the detention of vulnerable people considered to be relevant experience and expertise for this particular role?
I hadn't worked in detention policy prior to that. I worked in asylum policy, but in asylum policy I was responsible for primarily asylum policy in respect of LGBT individuals, women, children, so there was a kind of vulnerability angle to that, but I don't know whether that played a role in my being offered that post.
Thank you. You say that your involvement included visiting IRCs with Stephen Shaw and attending meetings with stakeholders, is that right?
That's correct.
Did you visit Brook House?
Yes, I accompanied Stephen Shaw on his visit to Brook House.
And if you can remember, which stakeholders would you have met with?
There were a range of stakeholder meetings. They're detailed in one of the appendices to the to Stephen Shaw's report. I would have attended a number of these. The only one I can remember with any accuracy, the name of the organisation was Women for Refugee Women.
Thank you. Did you take steps to inform yourself with an understanding of what the Home Office already knew about problems within immigration detention as it related to vulnerable people prior to taking up this role?
It happened very quickly, so I think there was only possibly a week's pause between me finding out that I was going to be doing the Shaw Review and actually starting. So there wasn't a lot of time to immerse myself in the detail of immigration detention. But Stephen Shaw was a good teacher, and I learned quickly.
Because it would have been important to understand why the Shaw Review was necessary, wouldn't it?
Oh, I understood that, certainly.
What did you understand as to why it was necessary?
My understanding was that there had been concerns growing over a period of time about the provision of welfare for immigration detainees, and specifically the Home Secretary at the time was responding to those concerns by asking Mr. Shaw to carry out a review.
Were you aware of rulings in Article 3 cases in the High Court, particularly in the cases of HA and D, both of which were cases where the court found an Article 3 breach whilst the individual was detained at Brook House?
I don't think I was aware of that at the time I started, but I would have become aware as time went on.
So you would have been aware that the court there had found failures of Rule 35(1) to identify the severity of mental ill health and in the ability of the detention environment to treat mental health. That was something that generally you would have been aware of during your time at the Shaw Review.
Possibly. It certainly would have been something that was discussed. Whether I engaged or needed to engage with that particular issue in any detail, I don't recall.
Do you know, or do you remember now, if you were aware at the time that the court had also ruled that the Home Office had breached its equalities duties by the introduction of a satisfactory management criteria into the policy, such that mentally ill detainees would remain in detention if they could be satisfactorily managed? Do you think you were aware of that issue at the time?
I don't recall that as a specific issue.
The court had ruled that the Home Office was required to do an equality impact assessment. They didn't, and instead the Tavistock Review was announced and then the Shaw Review. Were you aware of the Tavistock Review and the Shaw Review being in response to these cases of litigation, at least in part?
I can't say that I necessarily knew that connection. I may have at the time, but it wasn't a kind of major element in my role within the Shaw Review.
Were you aware prior to starting of the parliamentary inquiry in 2015?
I can't remember.
Because that inquiry had identified, amongst other things, inadequate health screening, inadequate health care, and safeguards for identifying vulnerability and mental ill health, and defects in the Rule 35 process. Were you aware of those as issues that had been identified prior to the Shaw Review?
I can't say that I was aware within the context you just described.
Were you aware at the time that the Home Office response to the parliamentary inquiry was that they would address those issues in the Shaw Review?
I may have been, but I can't remember at this distance of time.
If you weren't aware at the time, how, given you were the Home Office official seconded to the Shaw Review, how would those elements have fed into the Shaw Review? There
were 3 Home Office officials seconded to the review, and we, to an extent, compartmentalised our responsibilities. One of my chief responsibilities on the Shaw Review was to produce the review of policies Home Office policies in relation to detention. So another member of the team may have focused on those particular issues. Mr. Shaw himself was well immersed in all of these issues, I'm sure, and he obviously was the author of the report, and I think it possibly wasn't necessary for me to know those issues in detail.
Dealing then with the outcome of the Shaw Review and the key findings made, as part of his team, you would have been well aware of the findings and recommendations made by that review.
Yep.
It was important to understand those findings and the basis for them for the purposes of informing policy formulation for the adults at risk policy. Is that right?
Yes, absolutely.
And the formulation of that policy, the adults at risk policy, was primarily your responsibility. Is that right?
Yes, I was working in the policy team that was responsible for taking forward certain of Mr. Shaw's recommendations, primarily numbers 7 to 16, I believe, or 9 to 16.
9 to 16, I
Nine-
think you
9
say
to
in your
16.
statement. We'll come to those in a
Yeah.
moment. Shaw found that there were systemic failings in the Rule 35 process. He had said that it didn't do what it was intended to do, which was to protect vulnerable people. Were you aware of that as a key finding at the time?
Yes.
He considered that the cause of that finding was a lack of trust by the Home Office in the GPs completing the Rule 35 reports and in the system itself that the Home Office had created. Were you aware of that?
I don't remember that specifically, but I accept that
Did you
is the case.
Yeah.
if
Did
you
you
say
agree
so.
with it?
I'm not sure that I personally would have had the evidence to agree or disagree at that point.
Mr. Shaw said that training or redesigning the Rule 35 forms, the documentation, wouldn't alone address the issue. Were you aware of that finding?
Yeah, I mean, if I hadn't focused on that finding at the time, it certainly would have become apparent to me as I began to work on the adults at risk policy.
Shaw also criticised the phrase satisfactory management in detention in relation to mental ill health. Were you aware of that?
Yes, I am.
And he said in particular, it's perfectly clear to me that people with serious mental illness continue to be held in detention and that their treatment and care does not and cannot equate to good psychiatric practice, whether or not it is satisfactorily managed. Such a situation is an affront to civilised values. You were aware of that at the time.
Yes, I mean, I can't remember verbatim, but yes, in general terms.
He recommended as a result that key categories of vulnerability should be retained, but that a further clause should be added to the list that was in place at the time to reflect the dynamic nature of vulnerability and thus encompass persons otherwise identified as being sufficiently vulnerable that their continued detention would be injurious to their welfare, and that such a clause also would be helpful in relation to those with a disability. Presumably you appreciated that recommendation at the time.
Yes, indeed.
He had also found that there was a failure by Home Office staff to appreciate the difficulties faced by people suffering from PTSD and to recognise that detention can be re-traumatising. Was that something that you were aware of as a finding at the time?
Yes.
Professor Bosworth carried out a literature review in relation to the Shaw Review, and that literature review found that detention of itself was harmful to those with vulnerabilities and mental health. And Mr. Shaw, in his review, accepted those findings. Were you aware of that at the time?
Yeah, I think there was a general acceptance that detention had the potential to impact negatively on people, particularly those with mental health conditions.
Yes. Shaw was also particularly concerned that segregation may on occasions become the default location for those with serious mental health problems and without mental health care, which he said was not consonant with detainees' welfare and may represent cruel and unusual punishment. He found segregation facilities were not suitable for any detainees with a serious mental health condition. Were you aware of that at the time?
Yes, but it wouldn't have been something that I majored on because it wasn't directly related to the policy work I undertook subsequently.
Didn't you think that the fact that segregation was found to be unsuitable for vulnerable detainees with serious mental health conditions was relevant to an adults at risk policy?
The purpose of the policy was to provide a framework for making decisions about the detention or ongoing detention of vulnerable people. The segregation policy was an operational issue.
But wasn't it important to know and to consider when making detention decisions that if mentally unwell detainees were being segregated and that had particular risk of harm to them, that there should be an insurance that fewer vulnerable people were segregated or indeed detained initially if they were going to be subjected to segregation whilst in detention.
I can see your point, and that may well be the case. But as I said, the purpose of the policy was to provide a framework for making the decisions I described. You could argue that the policy should have gone wider than that and dealt with other issues, but...
Did you think it should have done?
I didn't consider that.
Do you now think it should have done?
I don't have a view.
The Shaw review also, there was a sub-review by Jeremy Johnson of Council in relation to Article 3 cases, which found that common features among the Article 3 cases going through the courts included that serious mental illness was not identified or treated, deterioration in detention leading to severe mental illness, and also incidents of use of force or segregation inappropriately, which related to systemic issues as to failures or breach of policy and couldn't simply be ascribed to individual decision makers. Were you aware of that conclusion?
I'm sorry, that was rather long. Would you mind repeating it?
Of course. So a sub-review was conducted into Article 3 cases that found that there were certain common features to a number of those cases. The first was that there was serious mental illness had not been identified or treated. Were you aware of that?
Not explicitly, no.
Secondly, the review found that in a number of cases there had been a deterioration in detention leading to severe mental illness. Were you aware of that?
Yeah, again, I may well have been at the time, but I can't remember considering that at the time.
And importantly, Mr. Johnson's review concluded that there were systemic issues as to a failure or breach of policy, and that those features couldn't solely be ascribed to individual decision makers. Were you aware of that there was a systemic element?
I'm not sure, to be honest. A systemic element in terms of decision makers.
In terms of failures or breaches of policy, not individual failures.
I'm aware of the fact that under the policy that existed at the time in respect of decisions on detention of vulnerable people, there was inconsistency of application because of the wording of the policy. And that was what the adults at risk policy was partly, at least, designed to address. So in terms of inconsistency, certainly, yes, I was aware of that, but systemic, I can't speak to that, I don't think.
As you've mentioned in your witness statement at paragraph 5, you were responsible for developing the Home Office policy on operational decisions on whether to detain and to continue to detain someone who was considered to be vulnerable. Would that policy development involve drawing on lessons learned from casework experience?
Yes, I mean, certainly the development of the policy involved operational colleagues and would have taken into account the practicalities of decision making and the experiences of decision making.
Would the policy development also have included drawing on lessons learned from previous litigation?
Obviously, we were keen not to develop a policy that would fall foul of the law, and so the policy would have been checked by lawyers to that effect.
Thank you. Would it have involved learning on lessons from inspections by independent oversight bodies such as HMIP, IMB or the ICIBI?
Yeah, we would have been aware of most, or if not all, things that would have had a relevance or a bearing on it. So views of NGOs and views of external bodies.
And so you would have taken all of those things into account when formulating the policy for the protection of vulnerable detainees?
Yeah, in the broadest sense, yes.
In looking at some of those in a little more detail then and how the policy was formulated, what process was in place to feed back to individual decision makers the findings of Article 3 mistreatment by a court or failures to implement policy lawfully leading to unlawful detention? what was the process of feeding those outcomes back to the people making the decisions?
Are you talking pre-adults at risk policy or after
well-
it was implemented?
Well, pre or post?
I think the answer is going to be the same, actually. So forgive me, but all I can talk about is what I would have done had I seen a case in which I felt that the caseworker had dealt with it inappropriately, which is to feed that back through either the line management chain or through colleagues in immigration enforcement who were overseeing implementation of the policy.
And did you do that at the time?
Not pre-adults at risk policy, because from the moment I stopped working on the Shaw Review, I started working on the adults at risk policy. So I had no responsibility for the operation of the policy that preceded the adults at risk policy. But after the adults at risk policy had been implemented, then if I saw a case, I would
And
go
you
to
say
the line managers.
if you saw a case,
Yeah.
how would the case come to your attention?
There may be circumstances there are two circumstances mainly, I think. First of all, if a casework team was unsure about how to manage a particular case, and especially in the early days of the policy, they would come to my team for advice on, for example, the level at which the individual should be placed at. And there would be other circumstances later on where we may have been reviewing the management of cases, to do audits of it, for example, in order to develop policy further, when I would have seen cases that I would have kind of questioned.
Where there was a failure to implement policy or a policy was wrongly construed, who is that information fed back to?
So by me, you mean?
Yes, well, by who and to who?
Oh, I see. Well, it would depend. I mean, there were various caseworking areas in the Home Office, and still are, I presume. And I had contacts in each of them at a fairly senior level. So if I saw a case that gave me pause, then I would speak to my contact in that area and leave it to them to engage with the relevant casework team.
And were you taking proactive steps to make sure you were aware of relevant cases?
There were, in each of the caseworking areas, individual senior managers with responsibility for safeguarding matters and responsibility for oversight and audit of those, of the operation of their caseworking team would fall to them. Sorry, I may have forgotten your question.
So were you taking you said
Oh, I
I
see.
would bring it to
Yeah.
the person's attention or the manager's
yeah.
attention if I was aware of the case. Were
Yeah.
you taking proactive steps to make sure you were aware of cases that were relevant to the detention decisions in relation to vulnerable people?
Thanks for reminding me. Only no. I mean, proactive in the terms of, was I actively seeking out reports or detention reviews in order to assess them? No. But as I mentioned, subsequently, when we would have been developing the policy, we would have asked for a number of cases on a number of occasions. But that would have been for the purpose of developing policy rather than auditing the...
Yes, and when you're there talking about
cases.
cases, you're talking about internal casework within the Home Office.
Yeah.
I'm also asking about cases that have been through the courts, where a decision has been made, a judgment has been issued, which either has criticised an individual decision maker or the decisions being made, or found a policy implementation to have been unlawful. How would you become aware of case law litigation through the courts of that nature?
In the Home Office, there was a team or a whole area which whose responsibility was to keep an eye on litigation, and they
But how did that feed into policy in relation to the detention of vulnerable people, which you were responsible for?
because any litigation that related to my area of responsibility would be raised with me by the team that kept a weather eye on ongoing litigation.
And was there a formal process for doing that?
I mean, if I'm brutally honest, it kind of, it felt semi-formal, and that I usually found out about litigation that was relevant to me, but it didn't necessarily always come in the same way. It was
ad hoc.
to a degree. I mean, I don't remember a time when we didn't hear about a piece of litigation, that was relevant, but it didn't always come from the same person.
And was it then your responsibility to reflect on those matters and make any changes necessary to policy?
Yes, but sometimes that could be a drawn-out process.
Yes. What about action against any particular individuals? Whose responsibility was it to follow up on that? For example, were disciplinary investigations ever carried out in relation to individual decision makers?
I don't know. That would have been a matter for caseworking areas.
What about if a judgment found that a policy itself was unlawful, or its implementation unlawful or contrary to parliamentary intent? What was the process for ensuring policymakers were informed of that type of failure? Is it the same process?
Yeah, so as an example, and you may well be coming on to this, I don't know, but when the adults at risk policy was implemented, we were immediately judicially reviewed by medical justice on the basis that the definition of torture that we'd applied in the policy. I happened to be on jury service when that was happening, so I don't quite know how we got that information, but we were served with a pre-action protocol, and the case went to court and an initial finding was made. So obviously my job then was to attend the hearing and respond to the interim judgment of Lord Justice Ouseley, as it was at the time, and take the necessary temporary action to address the judge's findings.
Yes, we might come to it in a little bit more detail later, but thank
Sure.
you. Was there any process to inform and feedback court rulings to the people on the ground, whether that was G4S management or healthcare management at all?
If a judgment required us to change policy in any way, then we would have amended the policy documents and the detention services orders if necessary, and they would have been usually disseminated to the healthcare staff and operational staff at immigration removal centres through detention services, which was part of immigration enforcement.
So it wouldn't be the ruling itself. There's been this court case. It would be, here's a new policy that's been changed. You need to act according to this one now.
Again, to take the torture example, we were required to revert to the previous definition of torture. So the actions we took at that point were to call in all the cases that had been considered under the adults at risk policy between the implementation date of the 12th of September until the judgment, the interim judgment, and review all those cases. And at the same time, immediately order caseworking teams to apply the judgment of Lord Justice Ouseley.
Yes, I see. Thank you. What about in relation to recommendations from inspections, such as from the HMIP and IMB? What was the process for those feeding into Home Office policy, particularly in relation to the detention of vulnerable people?
The usual process when a report, such as an inspection report, would be received, would be for a certain member of staff, usually in the operational area, in immigration enforcement, to assume responsibility for coordination of the Home Office response to the recommendations. Then that person would allocate responsibility for each of the recommendations according to who had responsibility for them, and then there would be a process of corporate consideration of the department's response to each of the individual recommendations.
And how was the process? What was the process for feedback back to you as to whether, as the person formulating policy and therefore presumably reviewing whether policies needed to be changed, from how it was operating on the ground? Was there a process by which you understood whether the policy was achieving its purpose and was operating effectively?
Yeah, I mean, we had very, very good communications and engagement with operational colleagues and colleagues who oversaw operational practices and processes. And so any requirement to change policy or consideration of a requirement to change policy would have been undertaken as a corporate operation, basically. So I, as a policymaker, would not be operating from a pure policy sense. I would be operating with full knowledge of what the operational position was, the operational needs and the operational situation.
And you mentioned your operational colleagues. What was the department and what level of role was feeding back to you?
The grade, you mean?
Yes.
Our forgive me if I can't remember the name of the unit, but there was a unit within immigration enforcement that was responsible for, if I remember correctly, oversight of the operation of the adults at risk policy by caseworkers. And our main contacts were there, and they provided a kind of umbrella of all of the operational practices in caseworking terms.
Thank you. In relation to learning from things that had gone wrong, were you aware that there had been some cases previously where there had been coronial inquests into deaths in immigration detention that had made various findings of failures in relation to those who were mentally unwell and the management of them under ACDT as a management tool, and failures in the Rule 35 process? Were you aware of those at the time?
I was aware that there had been cases of deaths in immigration detention. It wasn't something I was directly involved with.
Wasn't it important for you to know in the formulation of the adults at risk policy where something as critical as a death had occurred due to failures in safeguards for vulnerable people?
Well, I mean, to a degree, and in the broadest sense, I'd say yes. But my primary objective was to develop a policy that allowed for balanced decision making in respect of vulnerable people in immigration detention.
If we come then to the Shaw Review recommendations that you were directly responsible for, and you say in your statement at paragraph 12 that they were primarily recommendations 9 to 16, and those recommendations were essentially the foundation of the adults at risk policy, which was central to the Home Office response to the Shaw Review, weren't they?
Can I have a look at recommendations 9 to 16?
Yes, of course.
Is it tab 3? I can't remember.
It may well be. It's also INQ 000060 at page 195. Perhaps we can have it on screen.
So recommendations 9 to 16. The first few are, well, some of them are about specific conditions. Other ones are more general.
So number 9, please.
Number 9. So.
Here, as you say, there were some that related to specific categories of individuals. There we see victims of rape and other sexual or gender-based violence at number 9. We can also see at number 10 a presumptive exclusion from detention for pregnant women. And the recommendation was that the presumptive exclusion was replaced with an absolute exclusion.
Yep.
We see at recommendation 11, I recommend that the words which cannot be satisfactorily managed in detention are removed from the section of the EIG that covers those suffering from serious mental illness. Recommendation 12, I recommend that those with a diagnosis of post-traumatic stress disorder should be presumed unsuitable for detention. Those with learning difficulties, over the page please. Thank you. Transsexual people, a recommendation that the wording in paragraph 55.10 of the EIG in respect of elderly people be tightened to include a specific upper age limit, and at number 16 that a further clause should be added to the list in paragraph 55.10 of the EIG to reflect the dynamic nature of vulnerability and thus encompass persons otherwise identified as being sufficiently vulnerable that their continued detention would be injurious to their welfare. If you also just come down right to the one right at the bottom of the screen just now, recommendation 21, I recommend that the Home Office immediately considered an alternative to the current Rule 35 mechanism. This should include whether doctors independent of the IRC, for example forensic medical examiners, would be more appropriate to conduct assessments as well as the training implications, and number 22 underneath that Rule 35 should be applied to those detainees held in prisons as well as IRCs. Do you see those?
I do.
And although perhaps you weren't directly responsible for the implementation of recommendations 21 and 22, Rule 35 works in tandem with the adults at risk policy, doesn't it?
Yeah, to a degree. I mean, it's the only statutory reporting mechanism from IRCs of people who are vulnerable in any way.
Yes. Were you aware when the Shaw Review and its findings and recommendations were published that the Minister publicly accepted the recommendations, promised to reduce numbers of vulnerable people in detention, and promised improvements in the safeguards with a more protective policy?
I think the Minister used the term accepted the broad thrust of the recommendations.
But the idea was to reduce numbers of vulnerable people in detention.
Yes.
And to improve the safeguards with a more protective policy.
Yes, absolutely.
So that was the aim of the adults at risk policy which you implemented, is that right?
Indeed.
So far as you are concerned, did the adults at risk policy achieve that goal?
I think in terms of reducing the number of vulnerable people in detention, there may have been an unforeseen result in that because we had effectively broadened the scope of what it meant to be vulnerable, that had the impact of actually increasing. I can't remember the data, but this is an impressionistic view that I have from my time there. That it may have been the case that the number of people actually classified as vulnerable because of the broadening of the definition of vulnerability effectively meant that there were more people who were classified as vulnerable than would have been under the previous policy.
Just dealing with the consultation on the adults at risk policy,
Yeah.
Who sets the time period over which there is consultation on a policy?
I think there may be, in certain types of consultation, there may be a kind of statutory requirement. I may be wrong, but certain consultations are given 3 months, I believe, for certain things. Often is the case that because there was a desire because there is a desire not to delay things, that sometimes things are compressed. And so,
Do you think that happened here?
I think, I can't remember the exact timescales. I think we started working on the adults at risk policy obviously around the time that Stephen Shaw reported, or when the Home Office received the report, which was a few months before it was published. And the adults at risk policy went live in September 2016, I believe.
So stakeholders who were consulted were required to respond over the summer recess. Is that right?
Well, I think, as you'll see from having read the adults at risk policy, it's quite complex in many ways. And the development of policy, I found in my experience, is quite a long drawn out process because there's an awful lot that needs to be taken into account. You're trying to, especially in the immigration area and the adults at risk policy, you're trying to create a delicate balance between immigration control and protection of the vulnerable, and that is not an easy task. It's very complex, and so there were time pressures to get it done and get it out there, and what that meant, I think, possibly in practice, was that the amount of time that stakeholders had to consider it was compressed more than it may have been ideally.
You would have been aware at the time that concerns were being raised by, amongst others, medical justice before the policy was implemented, that it didn't accurately reflect Shaw's recommendations. Do you remember that from the time?
I don't remember specifically medical justice's views, but it would.
Do you remember concerns being raised that it didn't reflect Shaw's recommendations?
Yeah, I mean, and when you look at it, it doesn't reflect Shaw's recommendations because Mr. Shaw didn't recommend the adults at risk policy. He recommended finessing of the existing policy, essentially.
Yes.
But the Home Office decided to go down a different path.
Yes. And so the policy that we see as the adults at risk policy was implemented despite it not reflecting Shaw's recommendations and despite concerns raised at the time about that.
Yes.
Can we just look at some of the concerns that were raised then and get your view upon them?
Of course.
The adults at risk policy, as you mentioned previously, briefly sought to narrow the definition of torture to state actors or with state complicity, which was not a recommendation of the Shaw Review. Is that right?
That's correct.
Narrowing the definition of who is a victim of torture isn't going to strengthen protections for vulnerable people, is it? It's going to reduce them.
The reason we did that was that concerns had been raised by the operational business about the way in which the existing definition, the EO casework, litigation decision, definition, was used. It was based on 3 limbs: severity, intent, and purpose. And what was happening is that there were many cases, I hesitate to say many actually, there were certainly cases in which, and I can give you an example of the sort of case, if that would be helpful.
Yep.
So, for example, a common, this is an indicative case rather than an actual case, but there were many cases like this, or a number of cases like this, where, for example, a farmer and another farmer had a dispute over land or over property or over livestock, and one farmer assaulted the other farmer. Now, that kind of situation may well have met the 3 limbs of the existing definition, in that it could well have been severe, it could have cracked the fellow's skull. There was certainly intent because the person meant to do it, and there was a reason, punishment, for doing it. So it met the 3 limbs. So in legal terms, that met the definition of torture. But the view the Home Office took was that it didn't actually amount to an act of torture. And so the Home Office was seeing a number of cases where that was the situation. So the view was taken that by employing the formulation of an action by a state agent or on behalf of a state agent, that would cut out that kind of case from the definition.
But the concern being raised was that the risk of harm in detention to someone who's been the subject of torture is not defined by who the perpetrator is, but, as you say, under the test by the nature of the abuse against them.
Yeah, I mean, again, I think the view... sorry, I didn't mean to interrupt you.
No, you could go ahead, please.
I think the view was taken that the type of harm that we were looking to address and capture in the definition of torture was more likely to have been carried out by a state actor.
But you accept that on some occasions it wasn't?
Yeah, and I also accept, of course, that Lord Justice Ouseley found that the definition we had applied was not appropriate, was unlawful. He did, however, say that it was perfectly reasonable for the Home Office to pursue a definition of torture that was different from the EO definition.
Does that attitude by the Home Office indicate an unwillingness to learn lessons from litigation or something else?
Are you talking about the litigation in respect of EO?
Yes, is this an example of an unwillingness by the Home Office to learn lessons from litigation?
I don't think I'd quite put it like that. I mean, the way I'd put it is that the Home Office had operated the EO definition for, at that point, 3, 4, 5 years, and operationally found that it was flawed, and so the Home Office sought to find a different way of approaching torture. I don't think that necessarily represents ignoring the EAO judgment, but trying to find a better way of doing it.
Looking then at a different aspect of concerns raised with you about the adults at risk policy, the policy effectively moved away from the category-based approach to the assessment of vulnerability and replaced it with indicators of risk and evidence levels, didn't it?
It did, but I don't think that represents a moving away from the category-based approach, because the policy clearly set out the categories of individuals who would be regarded as vulnerable.
But they were categories of individuals who were indicated to be at risk, weren't they?
Yes.
And then what was then required was evidence levels at levels 1, 2 or 3 of independent evidence. That's right, isn't it?
Level 1 wouldn't have been independent evidence. That was a self-declaration.
Self-declaration. Levels 2 and 3.
Yes.
Level 1 not usually resulting in a release from detention,
No,
whereas the other two may do.
the principle was that the higher the level of evidence of risk, the more compelling the immigration factors would have to be in order to justify detention. And this is all, based on first principles of detention, that detention should only be used for the purposes of, if it was necessary in order to effect removal, and that under the Hard-You'll-Sing principle it should be for only if there's a realistic prospect of removal within a reasonable timescale.
Yes. This wasn't in accordance with Shaw's recommendation, though, was it? Because what he had recommended was keeping the categories, but effectively adding to them further categories of vulnerability, and we went through some of them: PTSD, pregnant women, learning disabilities, etc. And under the categories-based approach, people who fell within those categories were presumed to be inherently unsuitable for detention due to their vulnerabilities, weren't they?
They were held to be unsuitable for detention other than in very exceptional circumstances.
Yes, in very exceptional circumstances. And those categories of people unsuitable for detention were consistent with what Professor Bosworth had found in her sub-review, which was accepted by the Home Office. Would you agree?
I believe so, yes.
So requiring evidence of harm then goes against the principle that the categories of people are inherently at risk of harm in detention and shouldn't be detained, doesn't it? It provides an extra hurdle.
I'm not sure that it does, because as I said, the categories, and in fact an enhanced list of categories, in line with Mr. Shaw's comments, and going further, in fact, for example, in the case of individuals with mental health conditions, where the previous category referred to people with serious mental health conditions and the adults at risk policy referred to any mental health condition. I think the category-based approach was maintained in the adults at risk policy, but the policy was, the purpose of the policy was to address, or one of the purposes was to address the fact that the very exceptional circumstances formulation was vague and was subject to inconsistent application across the Home Office. And so we were looking to put in place a policy which achieved the balance between immigration control and vulnerability, but was, I know it is in some respects an inherently complex policy, but the overall effect was designed to be something that caseworkers would be able to apply in a much more uniform way.
Concerns were certainly raised with you about the move away from category-based, the category-based approach to an indicators of risk plus evidence of harm, though, weren't they? And that effectively went back to a practice of whether someone could be satisfactorily managed within detention. Do you agree with that?
Yeah, I think so. The satisfactorily managed issue is interesting because the EIG 5510 referred to satisfactorily managed in respect of people with mental health conditions and physical health conditions. We actually removed that from the formulation to a degree in the adults at risk policy, but I was reminded this morning when I read the document that was provided to me this morning, which was the 2016 version of the caseworker guidance, that it was kind of still there but in another form.
Yeah.
And so, I mean, I have to
And wasn't,
kind of agree with you that
yeah.
it wasn't removed.
Yes, and wasn't the concern about that was that it perpetuated a wait-and-see approach in relation to harm, such that harm would then actually be caused to vulnerable detainees in detention, rather than rooting them out of detention because they were inherently likely to suffer harm because of the category that they were in.
I'm not sure I quite understand. Are you relating that to the satisfactorily managed
Yeah.
formulation? I'm not quite sure I see the connection there, to be honest.
Whether, if there was a connection, that's certainly the opposite of what Shaw was trying to achieve, wasn't it? He was trying to root vulnerable people out of detention to ensure that harm wasn't caused to them by protecting them with safeguards. Would you agree with that?
Well, Mr. Shaw's recommendations in respect of the policy were, well, yeah, I mean, I can't disagree with that, yeah, sorry.
And in terms of that move away from the category approach, to the extent that it was, in that there was now an indicators of risk coupled with evidence of harm and this satisfactory management criteria retained in some form, whose decision was that? Was that your decision, or did it come from elsewhere in the Home Office?
I was responsible for holding the pen on the policy, but it was developed in conjunction with a range of colleagues across the Home Office, both operational and policy. Decisions, I mean, the adults at risk policy was a statutory policy. It was, there's a requirement in the 2016 Immigration Act for the Home Secretary to publish guidance on the management of adults at risk in immigration detention. The statutory guidance was in line with that, and that would have been signed off by ministers.
If we just look then briefly at rules 34 and 35 that work somewhat in conjunction with the adults at risk policy, were you aware at the time that rules 34 and 35 are required to work together as key safeguards, such that a rule 34 examination within 24 hours of a detainee arriving in an IRC can result in a rule 35 report, and indeed should in appropriate circumstances?
Yeah, I'm aware of the connection between Rule 34 and Rule 35. I think, well, I'll say that I was aware of the fact that issues raised at a Rule 34 appointment could potentially lead to a Rule 35 appointment.
And they should, if one was indicated, shouldn't they? Because the importance of those two rules working together is to identify people who are vulnerable to risk of harm in detention at the outset of their detention. That's right, isn't it?
I mean, my impression of Rule 34 was that it was partly about that, but also partly about identifying whether an individual had particular needs in detention.
Yes, certainly that in addition, but it was an important safeguard to ensure that the Home Office were notified about vulnerabilities in relation to a detainee at the outset of their detention, so they could factor those into their decisions as to whether to detain the person at all, weren't they?
Well, I would have, I think detention reviews were carried out at fairly frequent intervals, certainly at the start of detention. But
in the appropriate case, this should have been the first time, shouldn't it, as a result of that appointment?
I would have expected, if concerns were identified by the member of medical staff carrying out the Rule 34 appointment, if they had concerns, they would refer the individual for either a Rule 35 report, or would have notified the Home Office through other needs if the concerns didn't fall within the scope of Rule 35, and for that to trigger a review under the adults at risk policy.
Were you aware that the Home Office had effectively opposed the existence of a duty to undertake medical screening for torture before detention, because there was provision under Rule 34 and 35 for that to come out at the outset of detention.
I don't recall that.
That, if that's right, that would certainly mean that it's crucial that Rules 34 and 35 are acting in conjunction at that time, at the outset of detention, wouldn't it?
So could you tell me again what the Home Office had
So
decided?
the Home Office had opposed the existence of a duty to undertake medical screening for torture before detention. So that screening wasn't carried out before someone went into detention, which makes the safeguard at the outset of detention under Rules 34 and 35 all the more important, doesn't it?
Are you talking about in asylum cases?
In detention cases, in those
But you
going into
mentioned
detention.
before detention.
Yes,
so,
prior to detention.
But whilst an individual was being considered for detention, you mean?
Well, before a person comes into detention,
Yeah.
no screening is undertaken to ascertain
I see.
whether they should be detained at all because they're a victim of torture. And the reason the Home Office felt able to do that was by relying upon Rule 34 and
Right,
35
okay.
acting in conjunction at the outset of detention. Were
Well,
you aware of that
Chair,
at the time?
sorry to intervene here. I'm not aware of where that allegation comes from. It may well exist, but perhaps the witness can be taken to where the allegation comes from so that
Well,
he can see that
I'll-
in context.
I'll move on, and we can, if necessary, we can come back to it following this witness's evidence. In relation to Rule 35, when the adults at risk policy was brought in, there were no amendments made to the Rule 35 detention centre rules, were there?
No.
So we heard from doctors and indeed healthcare management and from medical justice from their experience of casework that the Rule 34 assessment was routinely not leading to a Rule 35 report, even where disclosures had been made, and that a further appointment needed to be booked for Rule 35, sometimes with delays in that appointment. Were you aware of that process at the time of formulating the adults at risk policy?
I don't remember being especially aware of that.
Medical justice had been raising those types of concerns with the Home Office for several years before the adults at risk policy was implemented, and indeed after it was implemented. You weren't aware of that at the time?
I don't recall.
That's a concern, isn't it, if part of the safeguards for vulnerable people in being picked up is Rule 34 and Rule 35 at the outset of detention, in the absence of a screening tool prior to detention. If that assessment isn't being made until some days or even weeks afterwards, that would be concerning, wouldn't it?
It could be potentially, yes.
Because it would be delaying the identification of particularly vulnerable people likely to be harmed by detention.
Well, yeah, I mean, we were keen for individuals with vulnerabilities to be picked up as early as possible, of course.
In relation to Rule 35, were you aware that the system under Rules 35 1 and 2 wasn't operating effectively in the relevant period or indeed afterwards, in that there were very, very few Rule 35 1 reports carried out and no Rule 35 2 reports at all?
I'm pretty sure I would have had access to data on the number of reports, and I don't know whether I would have seen the data in respect of the relevant period at the time. I honestly don't know, but obviously I've seen it now. And I mean, I think there's a couple of issues here. I mean, with Rule 35.1, I believe there were 2 reports in the period.
There were 8 reports in
8.
2017
Yeah.
and no
Rule-
Rule 35 2 reports.
No, none.
None.
Rule 35.1 obviously requires, I can't remember the exact wording, but requires doctors to report of cases where the individual's health is likely to suffer in detention,
Yes.
along those lines.
Exactly.
I think what was happening was that the vast majority of people who sought a Rule 35 report or were identified as being being the subject of a Rule 35 report were claiming to have been tortured. And I believe that there were different practices among doctors, among different immigration removal centres, where some, if they were presented with someone who had claimed torture and they considered that the individual may have been a victim of torture, which is the threshold.
They would do a Rule 35.3
They would do a Rule
report instead.
35.3 report. Now, if the doctor further considered that the individual's health was likely to suffer in detention, some would complete a separate Rule 35.1 report, whereas others would add that information onto the Rule 35.3 report. Now, as far as I was concerned, certainly, and I've seen something that suggested that the Home Office policy was that there should be separate reports. I mean, I think that was a bit of a grey area. The important thing for me was that the information was received by the Home Office, and my expectation would be that, and I know some very, very good IRC doctors who used the Rule 35.3 report as a means of reporting on Rule 35.1 as well. And my expectation would have been that had a caseworker received a Rule 35.3 report that went on to say the individual's health is likely to suffer, they would have placed that individual at level 3 of the adults at risk policy.
Dr. Uzerali gave some evidence that he had raised concerns with the Home Office that Rule 35 wasn't working, and he, in his witness statement, certainly mentioned conversations he had with you in particular. Do you remember the content of those conversations?
Well, no. I mean, I've kind of been partly reminded by having seen Dr. Uzerali's evidence from Friday. My recollection is that Dr. Uzerali was present at a training session I and a colleague from Immigration Enforcement delivered at Brook House. I think it was in October 2017. I may have the date wrong. And at the end of the session, Dr. Uzerali and I had a conversation. He came up to me and suggested that he had some ideas for improving the system. Subsequently, we had email exchanges, and I attended a meeting with Dr. Uzerali and Dr. Chowdhury, along with some Home Office colleagues. I don't know when that was. It was in the Home Office, which he expanded on his ideas and sought Home Office buy-in. As I say, I can't remember in detail what the ideas were. I think they were about separating out the therapeutic functions of doctors from the reporting functions, and maybe having an independent medical assessment within the Home Office.
Were you aware at the time of the low numbers of both of those levels of report?
I may have been, I don't know.
If you were aware, would it have been of a concern to you in the formulation of this policy that those two limbs of the rule weren't being used as required?
Not expressly, because I think I would have assumed that the absence of Rule 35.1 reports was because people were using Rule 35.3 reports to report Rule 35.1s effectively. And as far as Rule 35.2 was concerned, I was aware that the ACDT process had effectively, ran alongside Rule 35.2, but had in some ways kind of replaced the reporting need, because Part Cs were used to report cases of suicide and self-harm, or suicidal ideation and self-harm, and that any information needed by caseworkers to consider cases under the Adults at Risk policy would be getting through Part Cs or by other communication methods. And I think it's also important to remember that suicidal ideation and active self-harm does not in itself fall within the Adults at Risk policy, although it may be indicative that an individual is suffering from a mental health condition, and an act of self-harm or attempted suicide may lead to serious physical health conditions, which will bring someone within the scope of the policy.
Do you agree that there seems to be something of a disconnect between Rule 35, particularly under limbs 1 and 2, particularly, for example, where someone isn't a victim of torture but falls within those rules, and the Adults at Risk policy?
I guess to a degree, and I think, from what I've been reading over the past couple of weeks, the number
seems to be the case that there's still a disconnect.
The number of Rule 35.1 reports does give pause for thought, if nothing else.
In relation to the template that one has to fill in under Rule 35(1). Were you involved with or responsible for the development of the Rule 35 templates? The forms?
No, I don't think so. I mean, I think Rule 35 had been in place since 2001. I'm not sure about the development of the templates, but I don't think I was involved. I was later on when we were considering amending the Rule 35 process
Yes.
in my last months in the.
The template in relation to Rule 35(1) asks whether remedial action can be taken to minimise the risks to health in detention at section 5(2). That again forms part of reintroducing whether ill health can satisfactorily be managed in detention, doesn't it?
I never really thought very much about that, but the way you say it, I suppose so, yes.
Yes. It's certainly clear that that's how the doctors in Brook House were applying it, from Dr. Uzarali and Dr. Chowdhury's evidence. In relation to the template at section 5(4), there's a further question about whether release will adversely impact on detainee health as compared to treatment available in detention. That again brings in whether encourages consideration of whether someone can be satisfactorily managed in detention, doesn't it?
I suppose that's one way of looking at it, but it's also considering whether it's actually more dangerous to release someone than it is to keep them in detention. And I'm not for a second suggesting that it's preferable to keep someone in detention rather than release them.
Yeah. But doesn't it?
But it does mean. It does mean that special considerations would have to be put in place to ensure the safeguarding of the individual on release.
Yes. But doesn't it also encourage a higher threshold for the completing of a Rule 35(1) report? Because it encourages you to say, well, I don't need to make one if they can be satisfactorily managed in detention.
Yeah, I must confess I hadn't considered that before, but I suppose it does.
Similarly, the Rule 35(2) template says Rule 35(2) says that concern should be raised where there's a suspicion of suicidal intentions. That's a relatively low threshold, would you agree?
Yes.
There's no requirement in the rule to consider whether those suicidal intentions or risk of suicide can be managed in detention. That doesn't appear in the rule itself, does it?
No.
Why then does the template ask about satisfactory management of suicide risk and refer to management on an ACDT?
Presumably in order to ensure that the right care is being given to the individual, but I don't know, I'm speculating.
I mean, again, doesn't that encourage consideration of whether someone who has suicidal intentions can be managed in detention, and therefore there's no need to complete a Rule 35(2) report?
I suppose that could be one way of interpreting it.
We heard some evidence that the GPs, particularly in Brook House, but potentially wider than that, had come to the view that it was acceptable to communicate concerns about detainees' vulnerabilities, including self-harm or suicidal intentions, through Part C instead of Rule 35. Was that something you were aware of at the time you formulated the adults at risk policy?
I can't remember explicitly, but certainly we would have been operating in the knowledge that Rule 35 was limited in terms of the categories of vulnerability that could be reported under it. And so I certainly would have been aware of the fact that Part C and other less formal or more formal communications from doctors to caseworkers would have been needed in order to allow for the reporting of other vulnerabilities. And I think I was satisfied that was in place.
Well, Part C was certainly being used. Was Part C encouraged by the Home Office as an alternative to using Rule 35?
I don't think I'd go as far as saying actively encourage or discourage, but it was
known about.
It was known about, yeah, and it was simply a means of healthcare staff in IRCs reporting vulnerabilities to the Home Office.
But including where someone's health was being harmed as a result of detention, and also where someone was suicidal, but without the accompanying Rule 35 report.
Yeah, I mean, I can't explain, and I don't know whether this was the case, explain why a Part C would be used in lieu of a Rule 35.1 report, but I can understand totally why a Rule 35.3 would be used to report Rule 35.1 concerns.
Yes, thank you. Moving on then, if we just look at mental capacity, you were responsible for, or at least involved in, the drafting of the DSO 04/2020 on mental vulnerability, I think from paragraph 16 of your statement.
Yes.
This was the DSO that was drafted in response to the ruling of the Court of Appeal in the case of VC. Were you aware of that?
Yeah.
In that case, the court had found a breach of the Equality Act duties by the Home Office and discrimination against vulnerable detainees on the grounds of disability, because no adequate measures were in place to ensure that those who may lack mental capacity were not at a disadvantage in relation to their ability to participate in decisions relating to detention and removal from association under Rule 40. Is that right?
I think so, yes.
The inquiry heard some evidence that, in fact, that following that litigation, the gap effectively hasn't been plugged, and concerns are still being raised by those such as medical justice because of a lack of independent advocacy assistance for detainees who may lack capacity.
Yes.
Do you have any comment upon why that is?
I can't remember when the judgment was, but we found the production of guidance, the Detention Services Order, to be very, very complex, and it took us some time to actually get that in place. In tandem with that, we were looking at arrangements for an advocacy system, which I think we accepted was, certainly when I was there, I don't know if things have changed since then, but I think we accepted that that was kind of a key part of this. At the time at which we were ready to publish the DSO, when we just about sorted out the arrangements or proposed arrangements for identifying and supporting individuals who lack capacity in detention, we hadn't quite got there in terms of the advocacy process. There were all sorts of logistical issues. There wasn't, for example, a kind of off-the-peg advocacy service that we could utilise. So at the time I left, that work was still ongoing. But the view we took was that given that we were ready with the DSO on identification and support, we should press ahead with that, so that was, because we were coming under pressure from the courts to get this in place.
So despite the gap remaining,
Yeah.
and it potentially still leading to vulnerable people not being able to participate in their decisions about their detention and removal from association, the DSO was published,
Yeah.
and the gap remains.
Well, until such time as it could be plugged. I mean, I can't
Yes,
I can't
and
speak
I understand you've
to
retired.
what's happened since I retired, but that work was ongoing at the time.
You say in your statement that you didn't have a role in developing DSOs or policies concerning food and fluid refusal, is that right?
That's correct.
But isn't that a policy that's relevant to adults at risk and the adults at risk policy?
In the same way as self-harm and attempted suicide are not in themselves part of the adults at risk policy, the same considerations applies to food and fluid refusal and also to substance misuse, in that, again, they may be indicative of a mental health problem and they may lead on to a serious physical health condition. And I can explain the reasoning for that if it would be helpful.
Briefly, given the time.
It will be very brief. It's that those conditions, for want of a better expression, we did not want to promote in any way by all of the indicators in the adults at risk policy are conditions that people experience or suffer from. We did not want to have any activity in the adults at risk policy that could incentivise an individual to harm themselves, essentially.
Oh, I see.
I know not everybody would agree with that view, but that's the view we took.
Thank you. In relation to segregation then, again briefly, the Shaw Review had found a systemic misuse of segregation on mentally unwell people and expressed some concern about that, and medical justice have certainly given evidence that segregation is known to be harmful to those people who are mentally unwell. Would you agree with that?
I wouldn't disagree.
You had no involvement in the formulation of the Rule 40 or Rule 42 policy, did you?
No, I didn't.
Again, why isn't consideration given to the connection between use of segregation and the adults at risk policy? It seems to be, again, that there's a disconnect.
I mean, it certainly wasn't a primary part of our thinking in the adults at risk policy.
No.
But I understand that segregation is used for various reasons, and not just because an individual may be
Mentally unwell.
mentally ill.
Was any consideration given to the limits that need to be imposed upon the use of segregations, particularly on vulnerable people, in the formulation of the adults at risk policy?
It certainly wasn't something I was involved in.
In relation to the adults at risk reforms that were proposed by you in August 2020, again, there was a consultation, I think, with stakeholders at that time, and there were 3 key areas of reform proposed. The introduction of quality standards for external medical evidence in
Yes.
adults at risk, a change to the framework on detention of potential victims of trafficking,
Yes.
and then some reforms to the adults at risk safeguards themselves, including a change to the approach to assessing immigration factors concerning levels 2 and 3, and expanding the range of health professionals who may be authorised to conduct Rule 35 report assessments. Is that right?
That's correct.
We heard from Medical Justice and Freedom from Torture about some concerns that they have in relation to those reforms as being potentially regressive and reducing rather than promoting the protection of vulnerable detainees. Do you have any particular comment about that?
Well, I could talk to all 3 of them, but if you have specific questions.
Yes, so I'll go then to some of the detail of each one. So we heard evidence about the medico-legal report's quality standards, and that where a report doesn't meet those standards, it's effectively disregarded or at least afforded very limited weight. Do disregarded and afforded very limited weight effectively amount to the same thing in your view?
No, certainly not. I mean, I understand that the standards are now part of the policy, because I know that because I looked at the existing
Yes,
policy
they
the other day, and I was worried that wasn't the case when I left. But the principle was that some of the standards should in themselves mean that a report should be disregarded, because the way in which the report had been produced was clearly not up to the appropriate standard, but there were reasons to question either the veracity or the way in which the report had been produced. Whereas other issues, such as checking on previous medical history, may and I can't remember where that fell, but may have been less important than the actual
Yes.
way in which the report would be regarded.
Because there's a concern that in circumstances where the report is still of high quality and is therefore still of value in identifying vulnerabilities and those who shouldn't be detained, can be disregarded or afforded very limited weight simply because they haven't met a particular standard that's within these standards. Do you understand that?
I do understand, but
sorry, just because I know I'm quite limited
No,
on
that's okay,
time.
don't worry.
Sorry for interrupting you, but what I wanted to get your view on is really where, for example, the standards don't relate to the quality of the report, such as, for example, one standard is that the reporter has to raise concerns immediately with the IRC's healthcare department.
Yeah.
That has no impact on the value of what's in the report, does it?
Well,
but it's said in the standards may result in the report being afforded very limited weight.
one of the main things we were seeing was that, and I do remember this, that reports were being submitted by by medical practitioners via the legal firms, and they were being received 7-10 days after the report had been written, whilst at the same time the report was saying that the individual was at immediate serious risk because of detention. The issue that raised was that the author of the report was willing to attest to the fact that the individual was suffering harm, yet was willing to let them stay in detention for the time it took them to write the report and submit it to the Home Office. Now, we took the view, and I don't think this is unreasonable, that if those concerns were so real, they should have been raised with healthcare by the visiting practitioner immediately.
I see. At the time, the standards were said to be necessary by the Home Office because the Home Office had received a large number of reports that had fallen below the expected professional standards,
Yeah.
and that there was effectively an abuse of the system happening, a strategic approach, which is effectively what you've just described. Is that what you're saying?
I think so. I mean, I don't like to bandy the word abuse around, but
No.
the practices we saw certainly gave us cause for concern about the way in which these reports were being employed.
The ICIBI reported in their 2021 inspection report, reporting on the year 2020, and they recommended that the Home Office investigate and share their findings with staff and key stakeholders. Were you aware of that?
That was in 20.
So it was reported in 2021, but related to 2020.
I wasn't at work in
You'd
2021.
already retired by then. The Home Office, so far as we know, hasn't investigated and shared their findings. Again, would that cause a concern?
I can't speak for the approach the Home Office has taken.
In removing, under the new policy, an individual wouldn't be categorised as an adult at risk unless they had a professional assessment to support it, so level 2 evidence.
These are the proposals.
Yes, and so that effectively results in a removing of a level 1 self-declaration, doesn't it?
I'm trying to remember the details, but I know it was based on an assessment of the likelihood of the individual suffering harm. I can't remember the detail of that.
Well, if that's right, and what now to be classed as an adult at risk, if the proposal for change was to occur, if that's right, in order to be classed as an adult at risk, one would have to have independent evidence of harm. Then that results, doesn't it, in those who simply are self-declaring not being investigated and notified to the Home Office, potentially leading to a category of vulnerable people not being explored and reviewed for detention decisions. Isn't that a concern?
Could you remind me of what the proposed level 1 said, or there were 3 likelihoods of risk, wasn't it? Was it the high likelihood of risk, a medium or moderate, and low likelihood? So
Under the proposal for change, or under the...
No, the proposal for change.
Yes, there was a proposal that no longer was there to be a self-declaration as an adult at risk, and that's what I'm asking you about at the moment.
Right.
That in order to be classed as an adult at risk, one had to have not only self-declared, but also to have independent evidence. Doesn't that result in a category of people not being investigated and considered as vulnerable?
If the new level 1 would be people with a low likelihood of harm, they would have to be identified in the first place to be assessed as that. But I don't see that necessarily precludes individuals from raising a vulnerability, and then that would automatically lead to healthcare in the IRC assessing that and deciding whether what the likelihood of harm was.
But it doesn't lead to them being categorised. If it's simply a self-declaration...
But if that self-declaration leads to them being assessed by a healthcare, a member of healthcare, and then make that member of healthcare then making an assessment of the likelihood of the individual suffering harm, that will inevitably be either low, moderate, or high, and so that would lead to assessment. I mean, you'd have to forgive me. If you'd asked me that 2 years ago, I would have been able to tell you off the bat. But that's me kind of conjecturing on what I think the situation would have been.
Okay. The Shaw Review identified originally a culture of disbelief in healthcare. Did you take account of that in any way in the adults at risk policy?
I'm not sure that in his first report he said
Yes.
that. Yeah, I mean, I don't recall that, and I don't recall that being part of my consideration.
We know that the various bodies continued to remain concerned about aspects of the policy and critical of it and the safeguards in place following its introduction, following Shaw. That included Shaw in his second review in 2018 and included the ICIBI, the IMB and the HMIP in various reports post 2017. And I just want to look at, again, very briefly, some of those particular concerns and criticisms. Various reports have identified that Rule 35 continued to be systemically dysfunctional. There were delays reported in appointments with GPs. In 2020, there had been a dramatic increase in the number of Rule 35(3) reports in Brook House, and indeed, in 2020, there remained only 2 Rule 35(1) reports and still no Rule 35(2) reports, despite high levels of self-harm, high levels of ACDTs open, and including with detainees on constant watch indicating a high risk of suicide. Do you agree that the Rule 35 system continues to operate dysfunctionally?
I have no idea. I haven't worked there for 15, 16 months.
If those things are right, that must be correct, mustn't it?
That's an inference you could draw.
In relation to the second Shaw review, they found that there was still detainees in IRCs who should not have been in detention, and that the adults at risk policy appeared to have made matters worse, not better. Do you have any comment upon that?
No.
The IMB 2020 report reporting on 2019 found that the adults at risk system failed to capture deterioration in a detainee's condition and did not adequately capture an individual's level of vulnerability and may fail, therefore, to adequately safeguard vulnerable detainees at Brook House. Do you have any comment upon that?
Only in as much as, I have to disagree in general terms with the comment about the adults at risk policy failing to keep pace with potential deterioration in the individual's condition. It was certainly designed to be flexible, to be dynamic, as Stephen Shaw recommended, and combined with the fact that it required a detention review whenever anything was reported under it, if working in tandem with reports from healthcare that an individual is suffering from harm, the adults at risk policy should be responsive to that.
If it isn't, what's the explanation for that?
Well, either the information isn't getting through, or
It's not operating effectively on the ground.
I guess, yes.
The IMB report in 2021 reporting on 2020 found a continued failure to identify vulnerabilities and that the adults at risk evidence levels had not been addressed. The concern about the evidence levels being that the levels relate to the amount of evidence that the detainee is required to produce and not to their assessed level of vulnerability, and that this has been worsened by high numbers of vulnerable detainees. Do you have any particular comment on that finding?
Yeah, there's a couple of things there which I may forget as I go through them. The first thing is the policy was designed to be evidence-based because our view was that the best way of assessing an individual's vulnerability was on the basis of the evidence that was available, medical evidence predominantly, but any other evidence, social workers or whoever, professional evidence we accepted. Gosh, I'm so sorry, you couldn't say it again, then I can remember what
I can certainly, yes. So the concern was that there was a continued failure to identify vulnerabilities, and that the concern related to the evidence levels, that the amount of they require the evidence to be required to be produced by the detainee, and not to their assessed level of vulnerability.
Yeah. I mean, I think I'd say on that the proposals we were working on in 2020 were at least partly designed to really focus on the harm that an individual was likely to suffer. So still retaining the kind of evidence element in that it would be based on reports from doctors, but really focusing on what the issue was with the individual and whether they were going to suffer harm in detention. So I think that kind of half addresses that concern. But obviously, I don't know whether the policy has been put in place, but I don't think it has.
Finally, then, the inquiries heard a considerable amount of evidence about a toxic culture existing in Brook House in 2017, involving, amongst other things, institutionalised racism and the dehumanisation of detainees. And we've all seen the Panorama footage. I take it you'll have seen that as well.
Yes, I have.
Do you consider, in your view, that any deficiencies in the policies in dealing with vulnerable detainees, such as the adult at risk policy and the defects in the Rule 35 system, may contribute to such a culture leading to mistreatment of vulnerable detainees?
I've no reason to think that they do.
Thank you, Chair. Those are all the questions I have for this witness. Do you have any questions?
Thank you, Ms Simcock. And thank you very much, Mr Cheeseman. I just have one question in relation to something slightly earlier on in your evidence. Ms Simcock asked you about contact that you had from Dr Uzarali, and then you recalled having heard his evidence and gave some more information about that.
Yeah.
Do you recall ever having any conversations, contact, emails, meetings, any other correspondence with other GPs from other IRCs expressing concerns about Rule 35?
I can't remember expressly. There may well have been. There were. I didn't have a direct line to many GPs, and I don't recall ever having any phone calls from any other than, or emails from others other than Dr. Uzarali. We had engagement as part of policy development with a couple of GPs in Harmondsworth and Colebrook, and one in Dungavel. But I can't remember any explicit examples.
Would your expectation, was there a structure, I guess is my question, for how medical practitioners would feed in concerns related to the policy in an ongoing capacity, as opposed to a consultation when the policy was first written?
Yeah, there was a head. I think I'm not sure whether we covered all the IRCs or just the near London ones, but there was within detention services, there was a colleague who acted as kind of the liaison between healthcare within IRCs, the rest of immigration enforcement and policy, and we had very good connections with him, and I would probably have heard of concerns through him.
Can you remember that person's name?
Yeah. I think his name has been mentioned before. It's Terry Gibbs.
Terry Gibbs.
Yeah.
Thank you very much. I have no other questions, Mr Cheeseman. Do you have a follow-up, Ms Simcock?
I do, thank you, Chair. Not from anything that you've asked, but I've very helpfully been referred to the reference that the Home Office raised with me. Mr Cheeseman, I'd asked you about the importance of the Rule 34 and Rule 35 rules acting in conjunction with each other at the outset of detention in screening for vulnerability, given that there isn't a screening tool prior to detention in relation to screening out victims of torture. The reference came in the context of the case of D&K in 2006, where there had been argument about whether there was a duty to provide such screening prior to detention at common law. The court found that there hadn't. The Secretary of State for the Home Department had opposed the imposition of such a duty at common law in that case. As I said, the court found that there was no duty in law, but that also led the court to find that screening role of Rule 34 and 35 at the outset of detention was therefore all the more vital. Does that assist you in any way?
I'm sorry,
commenting
I
upon
really
that.
don't understand the question. I do apologise.
Wouldn't you agree that given that there's no screening tool and no duty to screen in relation to vulnerability and victims of torture prior to their detention, that the Rule 34 and 35 safeguards at the outset of detention are all the more important?
In the terms that you put it, yes.
And given that the Home Office, at least in 2006, appeared to oppose such a duty to screen beforehand, does that indicate a Home Office attitude in relation to the detention decisions in relation to vulnerable people at the outset of detention?
Does it indicate the...
Well, is there an attitude that there's no necessity to screen for this type of vulnerability either prior to or at the outset of detention in order to root those people out of detention? They prefer a wait-and-see approach to see if harm actually occurs whilst the person is in detention.
I don't... Thanks for putting it in those terms, because it does make it easier for me to address this in some way. This isn't an issue that I was directly involved in. I think the approach that I would have advocated is, as I think I mentioned earlier, that it's good to have as much information about an individual's vulnerability at an early a stage as is possible. There are processes in place. You've got a detention gatekeeper. You've got there is screening in certain areas of the business, certainly in asylum, and some, and that will capture some cases. I don't know about National Removals Command, but the principle for me would be get the information as quickly as you can. Sometimes, of course, an individual's vulnerabilities don't emerge until they are actually in detention, but I'm not sure it necessarily reflects an unwillingness on the part, if this is what you're suggesting, and I'm not certain it is, an unwillingness on the part of the Home Office to gather that information early. If there are reasons why particular types of screening at particular stages don't happen, then I'm afraid you'll need to ask the Home Office about that rather than me.
Yes. Isn't the danger, though, and the concern that if there isn't screening happening prior to detention and the Rule 34 safeguard is failing, that's leading to vulnerable people who shouldn't be being detained being harmed in detention because of the fact they are being detained?
I suppose if you accept that Rule 34 is the kind of fallback, the kind of...
Indeed.
The gate, and if it's true that it is not operating properly, then your concerns would be valid, I suppose.
Yes. Thank you very much.
Okay.
Thank you, Chair.
Thank you very much. Thank you very much, Mr. Cheeseman. My apologies that we've kept you slightly longer
There's
than
no problem
intended,
at all.
but it's been important to hear from you. I'm very grateful for your evidence. Thank you very much.
10 o'clock tomorrow.
Thank you very much.